Mr. Moyosore Onibanjo joins us now, also a legal practitioner, to continue our focus on the judiciary. Thank you for coming on this morning.
Thank you for having me.
So much comments going through, much as the former CJN did identify the need for that reform to go on, but how it should go, perhaps because even yesterday, the CJN now also raised some of the matters, and Mr. Ogunye did say it was more holistic than individual. Perhaps we should start from criminal prosecution or practitioners, because speaking to a number of lawyers, they raise this matter, which perhaps has not been raised as much as they need to. Extortion to get matters investigated, they say, because even when you file a case, to get a case investigated, to get the IPO to come forward with such cases, they have a lot of headache. Have you experienced any such?
Not particularly, because I've never prosecuted any criminal matter, but I've defended several criminal matters. I think, it boils down basically, in my view, to the willpower. Because you see that whenever the Ministry of Justice, be it the state or the federal Ministry of Justice, and that in turn translates to the executive, when they are determined to prosecute any particular matter that they choose to do, then you will see that the IPO will turn up. You see that all the witnesses will be in court. But where the will is lacking or weak, then you begin to have all kinds of excuses. Well, our witness is not around, the IPO has been transferred, and all kinds of things. I believe that we've been doing criminal justice administration now for maybe, 2/3 of our history, Nigeria's history. We should be able to get it right. I mean, why is it that the IG or the police authorities, when they know that this IPOs, have to be in their jurisdiction to give evidence in cases in which they investigated, why then do you transfer them to other jurisdictions and make it difficult for those cases to continue? There's so many things that one could go on and on about. These things they are recurring decimals. And the people who are in the sector, they're not strange bedfellows to them. They know that these are the issues. But why hasn't somebody, the Attorney General, the Governor, the President, put his foot down and say, look, we have to stop this, and this prosecution must be within certain time frames?
Would that be the job for the President to do? I mean, wouldn't that be interfering in an independent arm of government?
Well, it's independent to a certain extent.
Should that be the case? Independent to a certain extent, or fully independent?
Well, prosecution really should be fully independent. But the Nigerian situation is that you have the Attorney General, who sits at the apex of the prosecution team, is part of the executive. The president who is desirous of stamping out corruption, for example, can give marching orders to his Attorney General. Ditto a state governor can say, look, I am tired of this incessant problem of delays in the administration of justice. I want you to call your team and to ensure that cases are dispatched timelessly. That is what I mean. They need to be driven, given targets. For example, we would like to see figures from the various Ministry of Justices. In a certain judicial year, how many criminal matters were successfully prosecuted?
Do you think that would work, assuming it was the Chief Justice of Nigeria who was also, or who was delivering those orders, as it were?
Well, the Chief Justice of Nigeria can only admonish, because that office has no control over the office of the Attorney General. The judiciary is independent from prosecution in order for justice to be fair. The judges cannot be the prosecutors and the judges at the same time. They can only admonish, as the CJ did say yesterday, that look, this problem is not just, it doesn't boil down to just the courts alone. The prosecution must be up and doing. And if we look at our past, we cannot clap our hands for them.
It's really not too good a story, because you remember the other time Amnesty International also blamed the Nigerian judiciary what it calls unnecessary adjournment of cases. By now, we thought there should have been some kind of improvement, but this coming in from the CJ and some other lawyers on that day means that, well, there's just no improvement in that regard. Apart from deliberately, which they did say on that day, that lawyers would deliberately delay cases, what else would you say is responsible for these adjournments of cases, to the extent that we have some cases as long as 15 years still going?
It's a combination of so many factors. You cannot point the finger at just one factor as being responsible for this delay. Lawyers have their part of the blame. The courts, the judiciary, have their share of the blame. The prosecution have their share of the blame. The prison authorities have their share of the blame. So when you look at it, we need to rejig the entire system. Judges need to be firm. I think primus inter pares is for the judges to take charge of their courts, because there, for example, I practice a lot in Lagos. We know there are some judges who, once a case is assigned to them, if you're a lawyer and you know you have a case before those judges, you can bet your last dime that that matter is going to go on, because those judges are ready to go. But on the other hand, there are one or two people where they readily, if a lawyer comes to court and says, well, I'm sorry, I can't go on with my case, for any reason, they're ready to grant that kind of adjournment. But what we need to do is to be firm. For example, in the UK, what they do is that they fix cases for like a week. Say, in this week, your case is going on. And it will really take like maybe a nuclear bomb to be dropped there for that case not to go on.
What about some matters? Because we also hear them talk about, they say, for the fact that our legal system presumes everyone innocent until proven guilty in the court of law, then you have preliminary objection going on. Even, GT also, someone highlighted it could go from the magistrate court up to the Supreme Court. Yes. Lawyers coming up with all kinds of adjournment. How would you even, without even looking at the substantive matter, who's supposed to step in to stem this tide?
I think to stem that tide of lawyers filing preliminary objections at the onset of a trial and taking it all the way to the Supreme Court, we need to amend the Constitution. Because the Constitution gives you a right of appeal all the way. In the United States, for example, it's not all cases that end up at the Supreme Court. Only rare cases which really are not settled. But in Nigeria, it's an all-comers affair. It's really, to my mind, crazy for a matter to start at the magistrate court, go to the High Court, to the Court of Appeal and the Supreme Court. And you see, most of these matters that go to the Supreme Court, they are on the same principles, where the Supreme Court has repeatedly pronounced the position of the law on them. So we need to, the legislature needs to amend the Constitution to say perhaps that matters from the magistrate court should end up at the Court of Appeal. Matters from customary courts or area courts in the north should end up maximum at the Court of Appeal. So that the burden on the Supreme Court will be reduced, and they will only deal with extremely important issues of law or constitutional matters.